Detective Carpenter. So now the tide has changed. I'm pretty sure Detective Carpenter didn't realize, wow, that Brooks was going to be his own attorney, and he would have to be questioned by this fool. Isn't that such an irony and/or dichotomy? At any rate, let's dive in, and I will be making my comments intermittently throughout the duration of this content.
Back to that facility, you couldn't be held there. You couldn't be held at the stone. There's no beds.
You referred to interrogation starting at a specific place. I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes.
Yes, that's fair to say?
There was no interrogation at the substation.
I don't understand what's the significance of that. Well, why did it have to be at a specific spot? Like, is he trying to say just because it wasn't taken there, or the interrogation wasn't at the substation, that somehow was going to move the needle in terms of my defense? Like, you know what I mean? My thing is, if it's not moving the needle, then why even make that relevant? You know what I mean? Why are you asking them that? It doesn't mean anything, nor is it helping you.
In Waukesha.
Do you recall what information was obtained at the substation?
Yes.
Do you recall what that was?
Yes.
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks. Your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior. The date of birth, February 21st, 1982.
Wow.
Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods. Whether you were employed, going to school. I remember talking with you about your tattoos and other physical marks that might be on your body. Your hair color, eye color.
Wow, they got everything.
Photographs were taken. Things of that nature.
Now, I like how he's referring to him as on your person, things that we found of you. Talking about Darrell Brooks, the suspect, the person in question, the man that's interrogating me right now.
Kept mentioning that name, pretty slick.
That's because that's who you are.
Sure, disregard that last statement, sir. Please ask questions. You'll have an opportunity to testify later.
Oh, I got a lot of questions.
Yeah, a lot of dumb questions. That's going to be debunked once the state comes back on cross, my nigga. Oh.
And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
You have been
Why
identified.
was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
All right, so Darrell's gonna make a big deal out of because of, and I think I covered this in one of the last videos. Darrell's trying to make a big deal out of Carpenter not giving him information, and just like he just said, as I stated in prior testimony, they didn't have all the evidence. Darrell knew exactly why he was being detained. So in this clip, you're going to find out that he's trying to make it seem like the police station, they were wrong because they withheld information, and that's not true.
Standard procedure to not tell a person why they're being detained?
That's misleading.
Well, we did not tell you.
Right.
That's incorrect, and it's misleading to the court.
Absolutely.
You were informed you were being detained for prowling, loitering, disorderly conduct.
Is that the same as...
Can I finish, please?
Yeah, let him
I
finish.
just didn't bring up the parade part of it.
Why not?
Because it was developed, asshole.
As I stated in earlier testimony, it was very fluid and
Yeah.
chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
You know what Darrell's really doing? Darrell's really is questioning him just to find out how in the world did the detectives, the police outsmart what I did. That's really what this is. He's trying to figure out what did they do to outsmart him, because and guess what? You don't have to be smart to outsmart Brooks. Let me repeat that. Come on, touch a neighbor. Say, neighbor, oh neighbor, you don't have to be smart to outsmart Brooks. It was easy. The prosecution knew the case was easy. The only challenge that they were faced with was making sure that the jury, fell in line relative to the evidence that they have obtained against this fool. And I'm glad that they didn't deliberate on sympathy. I'm glad that they didn't deliberate because he was black or because he was a so-called minority. I'm glad that they did not side with a fool. Look at your neighbor and say, don't you side with a fool. Ooh, I'd rather side with the truth rather than siding with a fool. Y'all ain't saying nothing. All right, let's get back in here.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained.
That's false. That's misleading.
As I had stated in my earlier testimony, Mr. Brooks, I
Right.
explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
Now, how many times is he going to tell Brooks that? And how many times Brooks is going to keep asking him the same question? Same thing. You're not, in other words, you're not moving the needle in terms of a defense. You're not going anywhere, man. You in neutrality. You in neutral. This is circular. It's like a dog chasing his tail, man. And there's no advancement. So why continue? Why continue if it ain't going nowhere?
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
All right, can I say, let me just jump in here real quick. All right, so what Brooks is doing right now is basically playing semantics. All right, he said, so it wasn't a fact. He's trying to make it seem like, oh, it wasn't true. No, it wasn't that it wasn't fact. It was that the information wasn't developed yet. It was still in beta. It was still in production. It was still incrementally getting to us. So it wasn't that it wasn't a fact. It was that it wasn't fully developed. That's a big difference. Come on, man.
Objection.
Grounds.
Very vague.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
Wrong.
Objection. Same question.
Right. Vague.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
Yeah, what are you talking about?
All the information that you had up until that point.
What?
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
Exactly.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
He was involved. He was the driver.
And you knew that to be fact?
Based on the investigation?
Yes.
Yeah,
the
hell yeah.
information being provided was that you were involved.
Hell yeah, it was him.
So it'd be fair to say you knew that as a fact.
Well, hold on. I'm going to not allow him to answer.
Yeah, isn't that up to the jury really to decide on the facts? But it was a fact based off of the investigation. There's video evidence of him driving through the parade. I mean, how factual can you get? I heard, listen, they used to say years ago, a picture is worth 1,000 words. Touch your neighbor and say, how factual do you want me to be?
This jury will determine the facts of this case.
Exactly.
If you want to ask him his opinion, you do that at your discretion.
He said fact.
You asked the question.
You ask the question, sir.
Exactly,
So,
dumbass.
I'm going to strike the question.
Yeah, strike
on the
it.
record. And Mr. Brooks, you're directed to rephrase.
I wish that strike was from a vehicle that you striking Judge Darrell, to strike him rather than the question. Strike
I
him.
will rephrase, but I do not consent to being called that name for the record.
Noted and overruled.
He ain't going nowhere with this, man. This is a waste of time.
You stated that there were some loitering and prowling allegations. Why? To your knowledge, were those ever charged?
Objection relevance.
Grounds.
Yeah, what relevance?
The witness may answer.
No.
And do you recall why not?
No.
I don't recall. Good answer. I love that.
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Yes. Why does he keep going back to this?
Sustained. That's the form of the question.
First of
And
all,
assumes facts not
he already knows why he was told, and he already knows why he was being detained. Initially, because of his fight with Erica. That's why loitering. That was part of it. He knows. So him trying to pretend that information was being withheld, it's just ridiculous. You're not proving that. He's not proving that. The jury ain't buying that. And it was asked and answered a dozen times, and you keep going back to that, man.
evidence.
You keep going back to the same thing, man. Same thing, same result. Ain't nothing changing.
What was the significance of the FBI being present?
They thought it was a terrorist attack.
The significance of the FBI presence was the early on concern that this was a terrorist-style event.
Right.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
Are you that dumb? You don't know what this means?
When you drove your vehicle through the parade and struck people.
Oh, I love it. I love it. First of all, you got to understand, Darrell cannot stand him. He didn't like him even when Carpenter was interrogating him. He didn't like him initially. But see, Carpenter is getting under his skin because he's referring to him as his name, Darrell Brooks. And then he's saying, when you drove your vehicle, you don't think that's getting under Darrell's skin? Child, he is mad. Woo! And I just love Detective Carpenter because he's so strong. He's so potent in this. You got to realize he's a detective. He knows how to handle situations like this. This is not. You got to remember, Darrell is not questioning Erica Patterson right now. There is a difference. There's a level of intelligence now. Now you are actually being challenged by somebody now. That's just like Darrell put his hands on women. Well, now he's in a place where there are no women. And so now he's going to be challenged by a real man now. Y'all ain't saying that. Ooh. All right, let me get back in here. I feel good.
Which at the time you stated you did not know is fact, correct?
It wasn't
That was
developed.
still being investigated,
Right.
yes, but I know that's what occurred now.
Exactly. It wasn't that it wasn't a fact. It was just like it was a fact being developed, basically. Exactly.
Now versus
Darrell,
then.
let it go. Let it go. How is this a defense?
Initially, it was unknown if you drove.
That's what I
as
was
stated.
That was the question.
But-
Yeah, but they know now.
The investigation showed that you were the driver of the vehicle.
Exactly.
And initially you didn't provide that information, correct?
Does it matter?
Correct.
That's what I would have. I
So
would
do
answer.
you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
Right. He asked the dumb question, like they're really softball questions to the detective. Darrell, you're not.
I'm sure throughout your career you've done lots of interrogations. Are there usually multiple officers that do the interrogation, or usually just one?
Now watch this. Before he answers, you could tell that he's asked his questions, and I mentioned this earlier. His questions are geared to where he's trying to figure out how did you guys outsmart me, basically. That's exactly what this is. Because if you notice, Carpenter's just giving fluid answers. Because I keep on saying his questions, Darrell's questions is like softball to him. They playing softball right now. And he's just answering fluid. How they were able to outsmart Brooks. And what did I tell y'all earlier? You don't have to be smart to outsmart Darrell.
It can depend on the circumstance. It's not always more than one, but it can be.
Such a David said, it's possible to outsmart a dummy.
What would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
See, he's trying to figure out how do y'all outsmart me?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Right, how he gonna speak for
Up until
another
that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that day, no.
How does this amount to a defense? Still trying to figure that out. See, I think he
made
tried.
reference to
Now wait a minute. You notice how y'all notice how let's go back. Y'all notice how the wait a minute. I want to point something out real quick. Look how they just laid back, because this is softball, man. They know he doesn't have a defense. This is softball. This is a waste of time. They just chilling like, all right, when is this over so I can give my cross and we can just accelerate. Let's expedite this. Let's just get to the point, because we already know this nigga's guilty. All right, and or otherwise. And so they just chilling right now.
made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
Right, what are you talking about?
That a car key was found.
Even if he was told, it still links back to the Ford Escape, man. That links back to you being the driver. So where are you going with that? Where are you going with that? I guess he's trying to make it seem like he was told, but they don't know for sure. Nigga, it links back to your mom's car that you was driving. Again, you don't have to be smart to outsmart Darrell Brooks, apparently. He's stupid.
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
Exactly.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
Yeah.
At the time that
He don't know.
at the time
Hurry
that
up. Let's go.
the detainee was detained in the substation.
Thank you for that clarification. Go ahead and answer.
It still ain't clarified though, because what are you talking about?
I just want to make sure I guess that I understand. So you're asking me
Right. Clear it up. It needs clarification.
what I knew about the key, or if I knew where it was found at the substation. I don't understand.
Right. Me
Can you
either.
clarify that, sir?
Yeah,
I guess
re-clarify.
the clarity that you may be looking for is what was found and brought into the substation.
It was the key.
Okay.
That was on your person.
The Ford ignition key
Right.
and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name.
Exactly.
Debit card, credit and or debit cards with your name.
Exactly.
That you did not search and find yourself, right?
Don't matter. It's you,
That's
nigga.
correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in,
No, I knew those items were found on you in the search.
Because they were.
Maybe not the specific pocket, but I knew the officers found those items in your possession.
They sure
were
enough
you,
did.
were you at the scene of the search?
Doesn't matter.
No.
So how do you know where they were found?
That is a dumb ass question. I'm
Because
sorry.
they were turned over to Detective Stern as your property.
Exactly. Your property. Ah.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Yo, that answer was so profound because he did indicate in that interrogation room that he didn't know Waukesha. Remember, he was like, I don't know Waukesha. I can't tell. So in other words, why would it be believed that his stuff would just be randomly found there in a city that he claimed that he didn't really know that well? Yo, Carpenter is fire. Yo, he is on fire here. And he's making Brooks look dumb, which apparently ain't hard to do, given that he's already dumb. All right,
Can we
Look
strike
at-
that last answer?
we ain't striking
On the record?
nothing.
I didn't refer
Shut
to
up.
any house, grass.
You open the door. We ain't striking nothing. You dumb.
You asked
City.
an open-ended question. His answer will stand. Your
Exactly.
request is denied.
Exactly.
So it'd be fair to say that in the question I did not mention a house, grass, or a city. That'd be fair to say.
You didn't mention it, but I know you were found at a house in the city of Waukesha.
Exactly.
And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Exactly in the interrogation room. You look dumb.
Can you strike that?
No, we ain't. You
Last
open the
answer.
door.
Request is denied.
Exactly.
On what grounds, Your Honor?
Because you asked
You
them.
asked the question. He answered it. If you want to limit, ask leading questions.
No.
And direct him.
Don't tell him. Don't tell him that. Let him continue making an idiot of himself. He is stupid.
You
During
made
cross.
you made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you
Not based off of the
I'm
investigation.
referring to?
No.
Exactly. Darrell is stupid.
Even though it'd be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
There was nothing wrong with him. Because this shoulder
Are
seemed
you
fine.
yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd
Yeah,
be fair.
but here's the thing though. When they had left him in the interrogation room, you know, his shoulder seemed like it was fine to me. And that was after he had complained of having a shoulder pain issue. And then it turned out it was a lie anyway because they never slammed him. It was a lie. So it's the whole thing. You think the jury can't see through this? They see how his lies go from this to this and it just adds up. And the jury's job is to make sure that they base their judgment off of evidence. And it is evident that you have lied. So they're going to base their judgment off of the evidence of what you did and what you've been lying about. Exactly.
Fair to say?
I can't explain exactly what another's body's feeling. Correct.
But it doesn't matter. We saw
So
he
it'd
lied.
also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
Watch this.
I think that depends on the circumstance.
Right.
In this specific circumstance, you
Answer
told
the
me.
question, the last follow-up if he wants it.
No, I think the judge should have let him go ahead because he opened the door, and so all Carpenter's doing is basically making clarification to the court, because Darrell is essentially trying to make him look bad, and that ultimately is not gonna happen, man. You can't flip this on they did something wrong. You're escaping the whole narrative and the facts around what you did. This is about you. Detective Casey is not, okay, the person in question. He's not the subject. He's not the suspect. He's not the defender. Come on, man.
Next questions.
Did I say Detective Casey? I'm sorry, I meant to say Detective Carpenter.
You made a reference on one of the exhibits. I'm not sure exactly
Yeah, 'cause you
which
don't
one it
know.
was.
You don't know what you're
It
talking
was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence. Yes.
about. Okay, so now I want to fast forward, because this was a long interrogation relative to the nonsensical questions coming from Brooks. But I want to fast forward it to the state where the state picks up, just to pretty much easily debunk a lot of the things that Brooks was saying, trying to make the detective here look bad. Here we go.
Exhibit 174, which has previously been admitted into evidence. Do you recognize this form?
It ain't leading.
Overruled, the witness may answer. It's been testified to previously.
Talking about leading. I wonder what led him to do what he did at the parade. Like, why did you do that?
Sir, if you talk to the same person 3 different times while they're in custody, do you have to fill out a separate form each time you talk to them?
Objection.
Overruled. The witness may
Why?
answer.
Why is that an objection when you were questioning him? You opened the door. The state is coming in for redirect, basically to debunk and refute your whole narrative.
Yes.
Would you have to fill out that top portion of the form each time?
Yes.
That's all I need for that exhibit.
Exactly.
When we talk about, do you recall Mr. Brooks' questioning of you with regard to the recording
Objection.
made by your cell phone at Waukesha Memorial Hospital during the first meeting with the defendant?
Objection. I don't consent to being called that.
Overruled. That's your damn name. Shut up.
Voted. Overruled. The witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I
Objection
am.
leading.
Oh, overruled. The witness may answer.
Sorry.
What is that?
It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord and not response to a question. Typically, an utterance may reference why they're in custody in the situation that you were either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape or recording?
Objection speculative.
That ain't speculative.
Overruled. The witness may answer.
Yes, it is.
Would that be a reason to continue recording after an interview's been ended?
Objection. Answered that already.
It's cross
Overruled.
ass.
The witness may answer. It's redirect.
Right.
Yes, it would.
With regard to the 2 phones, you indicated that someone else located the phones in the defendant's car. Is that correct?
Yes.
And in order to access the contents of a phone, if it's passcode protected, do you need the passcode to enter it?
Objection leading.
Oh, overruled. The witness may answer.
And by the way, the code that he had gave Carpenter in that interrogation was a swipe. Now, everybody that has an iPhone, okay, now you know there's no swipe on an iPhone in terms of the authentication getting in the phone. That's not a part of that protocol. So he lied right there. Because that's not an Android phone. That's Apple. That's an iPhone.
It makes it easiest. The men that do that, the men and women that do that, do have ways around it, but it makes it much more difficult without it.
And it's really
And-
hard on an iPhone because the encryption is so potent. So it's really hard to get into a phone. But you certainly can't get into it doing a swipe. And so we knew he was lying.
Would it be fair to say that there's not all software can enter into all phones without the passcode?
Objection speculative.
That ain't speculative.
Oh, sustained as to foundation.
Have you had experience in your position as a detective seizing phones off of defendants?
Yes.
And have you had opportunities to turn those phones over to your forensic unit to have them analyzed?
Yes.
When you don't have a passcode or a swipe pattern, have you received those phones back with information that they were unable to be accessed?
Objection. Asked the form of that already.
It's cross,
Overruled. The
asshole.
witness may answer.
Yes, I
It's
have.
cross.
So if you're not provided a code or you're provided an incorrect code, there's a possibility, or are you definitely getting into that phone?
Objection speculative.
Overruled.
You asked them about it.
No, there is certainly a possibility that we would not be able to access the content.
Because the
You
encryption.
talked about on
And by the
cross-exam-
way, that's why what I like about iPhones. You know, the encryption is amazing. Like, there ain't nobody getting in your phone. They would actually have to reset it to get into it, but they ain't getting your information because it's highly encrypted.
your reports that you dictate over a phone line. Do you recall that?
Yes.
Those you testified were based upon your recollection.
Correct.
Do you take notes during interviews?
Objection speculative.
Overruled. You may answer.
Yes, I do.
Do you use those notes at all when dictating your report?
Yes, I do.
She's just basically debunking a lot of the stuff that Darrell was asking him.
The defendant asked you about
See?
multiple suspects. You having information about multiple suspects. Do you recall that line of questioning?
Yes, I do.
Did the defendant ever tell you that there was anyone in that car
Other than him.
than him driving it and possibly Erica Patterson?
Objection. Leading the witness.
They ain't leading.
Overruled. The witness may answer.
You ass.
No, he did not.
And finally,
And
you've been
by-
a law enforcement officer.
And by the way, you can ask leading questions on cross, and it's leading only because it's based off of what Carpenter was asked previously, and that was Darrell. Come on
in
now.
Waukesha County for approximately 18 years. Is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
The DA.
Objection. Leading.
That's
Overruled.
not. Even if it was leading, you asked him about that. You got mad because he wouldn't reveal to you the charges. Well, she's following up on that. All right? Debunking you because it's not his job to tell you what the charges are, because that's not the description or the job description of a detective. Their job is to piece together this story to see whether or not what you're saying parallels what we got. After we do that, then we turn the information to the district attorney, and then they will produce the charges for you. So all Attorney Baisley's doing is just debunking you because you tried to make him look bad. So even if it was leading, you opened the door.
The witness may answer.
The prosecuting attorney at the Waukesha County District Attorney's Office.
Exactly. They come
You
up
don't
with
you don't decide on the charges?
no.
No.
Objection. Relevancy.
It's overruled.
How are you gonna argue relevancy? Didn't you ask him about that? Didn't you want him to tell you why you were being detained and all that? What was the charges? What am I looking at? Remember he said that in interrogation? What am I looking at? Oh, you know what you was looking at. He didn't have to tell you that. That's up to the district attorney to decide what you looking at. Every time I see you, I'm looking at a no hairline. Woo! I was getting ready to say no fly zone. But no, this is a no hairline. Y'all ain't saying the woo, shout out.
We
You may answer.
we can forward what we believe is appropriate, but we don't ultimately make the decision to charge.
No, because it
When
ain't your
Mr.
job.
Brooks asked you, what am I being charged with? Did you have any ability to tell him that?
Objection. I don't consent to being called that name.
That's your name.
Noted. Overruled.
No,
You
he
may
didn't.
answer the
He
question.
did not have the ability.
No, ma'am, not with 100% certainty, no.
Nothing further, thank you.
Exactly.
Right, thank you.
Exactly. Yo, they made him look dumb. Now look at Brooks' face. Just look at his face. Look at that. Watch this. Look how he
Ladies and
looked at.
gentlemen of the jury, as Detective Carpenter is stepping off, I will read the instruction that I've
Look at it,
read
he
to
mad.
you every day, but it's important that you
Look
hear
at
it
it.
again. Do not begin your deliberations and discussion of
Did you see the way he looked at him? Because he knows he got debunked. Attorney Baisley. Now that's what you call a real attorney. You know, and when you got a real attorney, then you gotta expect that. It made sense. He came in, questioned Carpenter, and she came in with leading questions based off of what he asked and debunked them. That's how you operate as an attorney. Anyway, listen, y'all, give me your thoughts on this one. I would love to hear or read what you have to say in the comment section. Thank you for listening.